because because of paucity of time, other governors I could not reach, but governor of Manipur has sent me because there was one bill which was withheld. Same, nothing turns on that, but there was no political difference between the center and the state, but there was this bill. Your lordships need not read the bill; it's not relevant. Manipur agricultural produce and livestock I'm sorry.
Visual assent from this bill.
Agricultural produce, livestock marketing, so and so. But the reasons are given in the file notings. And there are also exchange of letters, calling the chief minister, calling for some details, etc., etc. But ultimately, my lord, then governor says, I withhold assent from this bill. So there is a declaration, my lord, just to answer your lordship's question, my lord. Second, my lord, I'm told that so far as the number of the act is concerned, if it is returned under the first proviso and sent back with or without modification, if that happens in the same year, then the same number continues. If it happens in the next year,
New number, yeah.
then new number, my lord. But there is something, my lord, on...
No, but in any event, when it goes back, it is confined only to that question and nothing more.
My lord,
So the House will deliberate on the question that the governor has asked the
My lord.
court to the House to reconsider. It will be confined to that and then return back. And in fact, many assemblies have made rules saying that there shall not be any
other discussion. Even Parliament has that rule.
All the
I'm sorry, my lord, Lok Sabha, Rule 132. I'll just read, my lord, and then I'll take my written submissions further. The debate on such a motion shall be confined to consideration of matters referred to in the message of the President or to any suggestion relevant to the subject matter of amendments recommended by the President. So,
November Arabia also talks a little bit.
yeah,
about
yes, my lord, we could find out, my lord, some legislative, but the position is virtually same, my lord.
They are far ahead of us.
Yes.
But we as lawyers seem to think that,
No, your lordships are far ahead. Your lordships have...
I'm saying the assembly is
No, my lord, constitutional framers were far ahead of us.
definitely.
But they could foresight, my lord, their foresight was, my lord, salutary. Yes, my lord, my learned friend, my lord, Mr. Maninder Singh wants me to say, and very rightly, that the language itself says, provided further that governor shall not so and so, in his opinion, it would reconsider the bill accordingly. So that accordingly restricts the scope of discussion. You cannot start a new discussion. It would be only confined to the message, potential amendment, etc. Now, my lord, if your lordships can take, my lord, my written submissions, and my lord, between the two of us, we'll try and we will conclude, my lord, before 1 o'clock, my lord. Try and conclude was a wrong expression, or loosely used.
We'll be grateful to you.
Pardon, my lord?
We'll be
No,
grateful
no,
to
no,
you.
but there is no point, my lord, in boring, my lord. At some stage, the courts are also saturated, my lord. We feel that we still want to bring our case home, despite knowing that rightly or wrongly, our submission has reached there, my lord, whether it's in my favor or against him. Lord, please come to page 767. This is a new point, my lord, I'm beginning with. The point is, my lord, other side, the learned councils, my lord, relied upon Article 213 to substantiate their interpretation. Seven, six, seven. Para 49. Lord, the argument was based upon Article 213. The interpretation which was canvassed by my learned friends, my lord, the learned council was that this clearly shows that there is no discretion in the governor. Lord, as a matter of fact, Mr. Datar went to the extent of saying, and I, my lord, as a constitutional interpretation, seriously object, that legislature has a right to pass even a void bill. It will have to be assented to, and only your lordship can set it aside. So
That's their argument.
yeah. So there is no option. Governor has not, forget 3 or 4, that's not the debate. There is no option at all. Then why have the governor at all? That's the simple argument. But, my lord, one of the argument was that promulgation of the ordinance, please see, my lord, the language used. I'll read, my lord, whatever is necessary, and I'll skip what is, my lord, already either orally paraphrased or earlier argued. If at any time except when the legislative assembly of a state is in session. So if the assembly is in session, no ordinance can be issued. Simple. Or where there is a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require. But I am not saying that read discretion here. It has to be his discretion. There is no doubt about it, but that's not my submission. That's not the only submission.
No, but
Provided that.
his satisfaction or the satisfaction rendered on the basis of the aid and advice of the Council of Ministers.
Therefore, I am saying it is not, my lord, my submission that it is his.
Normally, the ordinance making power is of the executive.
I am not disputing that. Therefore, I said that that's not my submission. I preempted, my lord, that it has to be as per aid and advice. But there is a discretion even after aid and advice. That is what I want to show. Provided that the governor shall not, the constitutional prohibition, without instructions from the president, promulgate any such ordinance if, kindly come directly to B. Lord, please read A first, Lord, so that it can be read in context. A bill containing same provisions would, under this constitution, have required the previous sanction of the president for introduction thereof into the legislature, like Article 30, 31, etc., etc., my lord. B is very relevant, my lords. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. If it would have been a bill, he would have considered it necessary despite aid and advice given to him by the Council of Ministers that no, this needs reference to the president. I must refer it to the president for his assent. Now, please see, my lord, see, an act of legislature of a state containing the same provisions would, under this constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. So, like Article 254, 254(2), the repugnancy. There is a repugnancy. So here, my lord, it makes it very clear that the framers of the constitution says that in the first part, yes, you will act as per aid and advice, as my lord, the Chief Justice very rightly pointed out, but he shall not do it if these three contingencies, and one of the contingencies be, he would have deemed it necessary. When the bill comes to him, he would have deemed it necessary to reserve the bill containing the same provision for consideration of the president. In that case, he needs prior instruction from the president in case of an ordinance. Now, please come to para 51. It may be pointed out that Article 213, page 767, para 41, 51. It may be it may be pointed out that Article 213 is a power to promulgate ordinances. The ordinance is promulgated by the governor himself. Subclause B will have to be read in the context. In view of the nature of the ordinance itself and the fact that the governor is promulgating the ordinance, the question for the grant of assent, first option under Article 200, will not arise, because ordinance, there is no question of granting assent. He himself is promulgating the ordinance. Similarly, second option of withholding under Article 200 will also not arise. The assembly not being in session is the precondition for exercising the power of promulgation, and therefore option of returning would not arise. Thus, there is only one option for the governor out of the four options mentioned in Article 200, and that is referring the bill for the president's assent. Now, my lord, this provision came in for consideration before a 7-judge bench of this honorable court, my lord, which was not cited till date, my lord, because this Article 213 argument came, my lord, orally in the and in written submissions also in the reply. Therefore, I am, my lord, respectfully urging the counter. I'm not in rejoinder. This is how the central government interprets the constitution. Please come to, my lord, Krishna Kumar 768. In Krishna Kumar Singh versus State of Bihar, a 7-judge bench of this court held as under. But then 231 is quoted. I am skipping that. The first of the above condition arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within the state, notwithstanding anything in Article 301 or 303. The proviso requires the previous sanction of the President before a bill or amendment for the purpose of Clause B can be introduced in the state legislation. An illustration of second requirement, that is point 2 above, point 2 where B is provided by Article 200 of the Constitution, under which the governor is required to reserve for consideration of the President any bill which, in his opinion, would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is designed to fill by the Constitution. Situations where the assent of the President is required, then point 3 above are illustrated, my lord, 254, etc., my lord, where he will have to refer it to the President. There is a clear repugnancy, my lord. That's what the court said. Illustrated by Article 254, where a law made by the state legislature on a matter enumerated in the concurrent list of the 7th schedule is repugnant to a law made by Parliament, the state law will prevail only if and to the extent to which it has received the assent of the President. These three situations make it abundantly clear that while exercising the power to promulgate an ordinance, the governor is not liberated from the limitations to which the lawmaking power of the state legislature is subject. So, my lord, as a matter of fact, Article 213 aids my interpretation that despite there being contrary aid and advice, the governor has the room for discretion. So that's the respectful submission supported by, my lord, a 7-judge bench judgment, my lord. And I have, my lord, now given the contingencies for such reservation over and above the express clauses under the Constitution cannot be illustrated exhaustively, but may depend on the following factors. My lord, please pause here for a minute. My lord, I have cited in my initial respectful submissions and even during these submissions that there are judgments which says that irrespective of constitutional provisions, there are discretions available, calling the minister, calling someone to form the ministry, etc., etc. Lord, in none of those cases, in all those cases, the Supreme Court was very clear that these are only illustrative and not exhaustive. Because the Supreme Court was very clear in my submission that there may be circumstances which may arise in future where, other than the illustrations which we give, the governor may have to exercise his discretion. I'll come to that. But I have given, my lord, the broad parameters within which, my lord, he will have this discretion, where the bill is capable of subverting the Constitution. Nobody can dispute this, my lord. Where the bill is undermining the Constitution. Where the bill erodes the principles of democracy. Where the bill is of such a character that it has a national implication. My lord, therefore, my lord, I have given an example of Punjab water dispute. Lord, 4 states involved, Punjab, Haryana, Rajasthan, Delhi. There was an international treaty with Pakistan. And one assembly said that we revoke the agreement entered into. And, my lord, now we are faced with an argument that you have no option. Even a void bill, you will have to grant assent to.
This court granted stay of that.
Yes, obviously, my lord. But, my lord, that would not take away the power of the governor. My lord, kindly, my lord, appreciate. Your lordships are right. Your lordship stayed it. But that would not have taken away the power of the governor also to withhold. That you can't do this. This affects the federal structure. 4 states are affected. The center is affected because there is an international treaty in place. My lord, then, my lord, second submission, my lord, which I have made, but I wish, my lord, some of the judgments to be only relevant parts to be shown. My lord, I gave certain examples, my lord, that suppose the assembly passes a law that we will have a separate force. They may not term it as an army. That would protect the borders of my state, for example. Or a person belonging to a particular community will not be permitted to have any trade and business. These are extreme examples. Now, my lord, this section of my written submission deals with, then in past also, Supreme Court has dealt with extreme examples while interpreting Constitution of India. Because what your lordship decides today will be the foundation as to how the country will govern, number one. Number two, the Constitution will have to be interpreted with the harshest of the examples because it will have to withstand the test. There are many acts which are passed today which possibly would not have been contemplated, my lord, 70 years back. Now, please see, my lord, I have given the example of Lord Nani Palkiwala giving extreme examples that somebody surrenders the sovereignty, takes away the right to vote from a particular class of persons, or confers right only to a particular class of persons. Somebody say, my lord, some government come out with a say, as a, my lord, cheap publicity gimmick, that we will not tax anyone except some industrialists. These are not, my lord, these are, my lord, possible potential examples. Supreme Court has examined extreme situations. Please come to page 771. Lord, in Keshwanand Bharti, only I'll read the highlighted part. Lord, if this is so, Lord, please see the extreme examples which are tested. If this is so, a political party with a 2/3 majority in parliament for 4 years could so amend the constitution as to debar any other party from functioning, establish totalitarianism, enslave the people, and after having effected those purposes, make the constitution unamendable or extremely rigid. This would no doubt invite extra constitutional revolution. They have considered that if we interpret it in a particular manner, this kind of bills also can be passed. Mr. Palkiwala gave an example that suppose Article 368 is amended, conferring power to amend on the executive, that henceforth the government will amend the constitution.
These observations
Yes.
are in response to the argument that the parliament's powers to amend the constitution are unbridled. So, rejecting that argument, these observations have been made.
I'm sorry, I'm saying the same thing. I'm unable to convey it the way, my lord, your lordships have very pithily conveyed. What I'm saying is that while answering the proposition that we have unbridled power, the court has examined and conceived extreme situations, that we have to keep these situations in mind, that if we allow
your submission is that while interpreting these provisions, we also have to take into consideration the extreme situations that may arise.
I have brought my point.
Arise in future.
Yeah, I have brought my.
We have to be cautious while
Yes.
holding whatever we are proposing to hold.
Yes. My lord, only, I am not, my lord, then reading rest. But, my lord, one judgment, my lord, which I found it interesting, is again, my lord, a 7-judge bench, State of Rajasthan versus Union of India. The lordships were shown in a different context. Here, my lord, the example which was given was that this was a case of 356, my lord, President's rule. Janta government, my lord, my lord, dismissed all Congress governments in the state. And that was under challenge. And, my lord, the not almost 7, my learned friend is right, 7 state governments in the state, in different states. And the question was, what can be the judicial review of 356? So 356 is an executive power. It's not a legislative power. That's a separate thing, unlike Article 200. The court says that we will examine only if there are certain exceptional circumstances. And one of the example, your lordship may come to para 773. Another extreme example, but an interesting extreme example. Page 773, my lord, the highlighted part. Lord, take for example, if your lordship, my lord, can come to that. Court is examining the justiciability or power of judicial review or the restrictions thereof. Take for example, a case where, I'm sorry, my lord, your lordship gets, my lord, somewhere, my lord, the highlighted part, 5th, 7th line from the top, last word is take. Take for example, your lordship gets, my lord. Yes. Take for example, a case where the president gives the reason for taking action under Article 256 and 356 and says that he is doing so because the chief minister of the state is below 5 feet in height, and therefore, in his opinion, a situation has arisen, then we can interfere, etc., etc.
This one is very reasonableness.
Point is, there can be extreme, there will have to be extreme examples on which you test the constitution.
At this point, it's an age-old technique to test the correctness of a proposition. You examine the extreme situation. It's an age-old technique, so there's nothing new.
Correct.
You take Lord, this point, you can go ahead.
Yes, my lord. 776, my lord, I have seen withholding as a separate option, my lord. And I'll just...
Your proposition is that while interpreting the provisions of 201,
yes,
we'll have to take into consideration the extreme situations that may arise. And therefore, we have a cautious approach.
No.
For the governor to consider that.
No, my lord. For the governor, yes. Therefore, withholding can be an option. Therefore, withholding is an option. To be used rarely, my lord. I cannot, my lord, argue that he can use it wherever he feels. But something so shockingly unconstitutional, something so, suppose some legislative assembly passes a bill that henceforth we will not be a part of Union of India. Would he, my lord, return it? Would he grant assent? Would he refer it to the president? The only thing which can be done is to withhold the assent. Therefore, I said, my lord, I'm not repeating it, that there are only 20 instances, my lord, in last 50 years. Now, Lord, withhold is a separate, my lord, action, a separate independent option. I have already argued it, but my lord, I was just trying to assist your lordships on the question, what is the meaning of the word falls through? What is the consequence of withholding of the assent? My lord, falls through, as my lord Justice Narasimha, my lord, pointed out, that it's not a constitutional term. It's not a term used. My lord, Constitution uses the term lapsing. But lapsing is a separate phenomenon. My lord, suppose a bill is moved, but the assembly is dissolved, etc., then the bill lapses. But withholding, every judgment of the Supreme Court uses the word, in case the governor withholds the bill, it falls through. From where? We were, my lord, searching. From where the Honorable Supreme Court got these words? I'm not reading it, but please see wherever amendments were moved and were not accepted. The Constituent Assembly debate says that this amendment is not accepted. Please come to 778. I'm not reading it. 778. 778.
8.
Yes. Therefore, my lord, from the beginning of the conceiving of the Constitution, the word falls through is that it does.
Yesterday you said that they were put before the Constituent Assembly, and the Constituent Assembly did not approve of them. So therefore it fell through.
The governor, my lord, withholds it. Therefore, if the
Can
word...
you equate the governor with the Constituent Assembly?
No, my lord, I'm sorry, my lord. And that's not the comparison I'm making even remotely. My lord, that's not my submission. My lord, my submission, I'm sorry, my lord, there is some limitation. I'm unable to communicate properly. My submission is where the word falls through.
The origin of false through.
Comes from.
The origin of false through. The origin of false through.
Origin of falls through,
Is
falls
constitutionally
through,
dependent.
falls through means dies. Amendment not accepted, it dies. From this, my lord, every judgment of the Supreme Court, larger bench judgments, says in the context of withholding that if it is withheld, the bill falls through, meaning thereby it dies. That's the only limited purpose.
Unless.
My lord, that I have already, my lord, I don't wish, my
Proviso
lord,
is followed.
repeat it, my lord, I have already, my lord, argued that, my lord, then the chart is given. Unless, my lord, I don't think, my lord, I'll take that, my lord, further.
Unless my lordship permit me, my lords. My learned friend gave this sheet to your lordships,
Yes.
which is said withheld. So it falls through, but it was passed.
Yeah?
This very bill was passed. Governor's assent was given.
On the-
According to my learned,
After sending it back to
yes,
the.
yes, his government has given. According to him, the moment he withholds intent, it falls through, contrary to my lord's own action.
No, my lord, I
This
do
was
not know
passed,
from
note
where
the
he
date,
gets it.
Assent given on 26 to 21. It became an act 15 of 2021. Anyway, I'm sorry to interrupt.
My lord, this is a reference made by the President of India. It is not necessary that one party will only appoint the governors. The argument from the other side is that perennially we will never have our governors. Let's not, my lord, go into that. My lord, here I'm not going into this question. My lord, here what happened was, let me tell you.
The Constituent Assembly was considering the provision of governors. The expectation that the framers of the Constitution had was that it would be an existence in harmony.
Correct.
Normally, while appointing the governors, the provincial governments would be taken on board. That was the
Lords,
expectation that
my
time.
lords, the system has functioned with harmony. This has a recently started phenomena with Delhi government. Something happens 32, something happens 32. Otherwise, my lord, there are several governments, my lord, communist government, Congress government, Congress in center, BJP government in state. Did your lordships get 32 petitions? They were being taken care of. And what my learned friend is, my lord, possibly assisted wrongly is this bill was withheld and therefore it fell through. Thereafter, in 2021, some new bill was introduced.
This very bill, don't say.
It cannot be this bill, my lord, after follow. Lord, Sibbal Sahab, aap
Take it up.
don't take instructions from unreliable sources.
You can place that
I will place it.
on record. Yes.
But my lord, that again, this is only to answer.
Only to examine whether after withholding, the governor again sent it to the legislature. The legislature
No.
again passed the bill, and thereafter the
No, it cannot. Lord, therefore, my only purpose of showing this is that
May I say this, Lord? Your Lordship permits.
he's
Tamil
obsessed
Nadu-
with Tamil
Tamil
Nadu.
Nadu's
I
case.
understand, my lord.
10 bills, my Lord, were sent as withheld. Again, my Lord, it was reconsidered and sent. And that is how, my Lord, the court said, second time when it is
We
reconsidered.
are not going on the facts. Mr. Wilson, why are you unnecessarily? We know that
I'm giving example.
for you it's a important matter, but that doesn't mean that
I'm
you
giving
should.
example, my Lord.
Lord, what happened was,
As per the practice book, at least I have seen for a couple of years, while withholding, also invariably the governor gives a reason.
they do, yes.
And sometimes it is in writing,
No, mostly in right. Yes, your lordships are right.
for informal or formal, the reasons are communicated.
And there is an end.
And after the communication of those reasons, there is nothing which preclude the legislature
To pass a
to
fresh bill.
reintroduce, reconsider
Exactly.
a bill where certain modifications may or may not.
Correct, my lord, correct.
Certain.
I bow down, my lord. That's all I am saying. The file, my lord, which culminates into this declaration contains correspondence, reasons, calling for some explanation, some details, meetings between the chief minister and the governor. Lord, this adversarial approach had never been taken. Since 50 years, we have the example. Now, my lord, page 780, my lord, I have given the authorities on plain meaning, etc. My lord, I am not troubling your lordships.
Page
But
7,
780, my lord, 780.
80 you said.
Yes, my lord, that the interpretation has to be plain textual meaning and not, my lord, anything else, my lord. But I am not reading them, my lord. They are settled propositions. I have cited judgments, my lord, which were relevant. My lord, most of them are constitution bench judgments, and only one paragraph, my lord, your lordships can permit me to read. My lord, Jai Shri Lakshman Rao Patil, my lord, that reservation matter, page 781. So it's a basic proposition, but very well articulated. I'm not reading it because otherwise I'll have to cross my time limit. But just see the highlighted part. The first and primary rule of construction is that the intention of the legislature must be found in the words used in the legislature itself.
there can't be any dispute with regard to
Therefore, my lord, I didn't read, my lord. I'm not reading that.
the golden rule of interpretation.
Yes. Now come to 785. My lord, kindly treat them as read. That's all. I am citing it. 785.
That allowance you must give it to at least all 5 of us.
No.
That we know the basic rules of interpretation.
The very fact that I did not read and said that I am not reading because your lordships are aware, I started with that, my lords. Lord, 785 is a very important, my lord, point, which was raised by my learned senior Mr. Gopal Subramaniam. Discretion, aid and advice, and the necessary implication. My lord, allow me, my lord, to spend, my lord, 10-15 minutes on this point. My lord, his argument was that the discretion is only, kindly, my lord, discretion is only provided when it is so provided either by or under the Constitution. Correct? No, that was his argument. Now, please come to para 90 at page 785. So, therefore, my lord, the argument was that wherever either by or under discretion is not conferred, discretion does not exist. Correct? My lord, that was the submission. And very well articulated, my lords. My lord, para 90. The Constitution confers certain discretionary powers expressly. Certain discretionary powers are read as implied either because of the nature of the power, the subject matter of the decisions, or the functionary exercising the power. Article 200 is an example of certain implied discretions when the fact situation under which the government is supposed to act, governor is supposed to act, so requires. Even under Article 163, there can be implied discretion not to be guided by aid and advice. This is for the reason that sometimes exercise of power under aid and advice defeats the power itself. My lord, take example of Special Police Establishment Act. My lord, suppose the Chief Minister is facing allegation and there is a question of sanction. 197 section or section 17 PC Act or 19 PC Act. He would still, my lord, I am saying, my lord, as a constitutional principles, I am not taking an extreme one-side view. He would still require, my lord, the aid and advice of the Council of Ministers. But he can still say that, no, this is clearly a biased advice. I am not bound by it. The council may say that don't grant sanction. And none of these provisions, my lord, the distinction was sought to be drawn that they are statutory provisions. No, the provision for which under which sanction is required, PC Act or Bharatiya Nyaya Sanhita, may be statutory, but his power which he is exercising is under Constitution. Because he is the appointing authority under the Constitution, he decides whether to grant sanction or not. There is nowhere which is mentioned that this would be done in his discretion, but that is by very nature of the power an implied discretionary power. Look, kindly read it further. It is submitted that, for example, of under the Constitution, by the Constitution there is no dispute, under the Constitution, discretion is evident in the following. The power to summon assembly does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. He can summon the assembly, my lord, to ask for the floor test, etc. Second, the power to order a floor test does not use the word in his discretion. However, it recognizes that in certain situations, the said power can be exercised in his discretion. The power under the second proviso to Article 200 does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. Lord, the power to grant sanction against the chief minister or ministers does not, I have not already pointed out. Then 356, it doesn't say in his discretion, but the nature of the power is such. He would never get advice from the Council of Ministers that you report under 356. So, my lord, to say that it has to be either by the Constitution or under the Constitution, my lord, would be a wrong constitutional interpretation. Lord, for which, my lord, for example, Lord, my lord, MP Madhya Pradesh Assembly, my lord, Shivraj Singh Chauhan, my lord, when this issue, my lord, came, Lord, this honorable court has said that this has to be done as per the discretion of the governor. Whom to call, when to summon the legislative assembly, floor test, etc., etc. They are neither by or under the Constitution. The discretion is not by or under the Constitution. It is read as an implied power because of the very nature of the power. Then, my lord, kindly come to 95. And, my lord, this again, my lord, I have, my lord, raised a very serious concern. I'll not say objection. How you selectively place the judgments before the court. This was done before the division bench in Tamil Nadu case and unfortunately repeated before your lordships. Despite my pointing out that two paras are not read before the division bench and therefore the division two-judge bench.
That's nothing new in the Supreme Court.
Pardon?
That's nothing new in the Supreme Court.
Their lordships.
Not only paras, but even the sentences are selectively read here.
Some words are not read. That's anyway, Lord, please see Nabam Rabia. Para 95. Lord, kindly allow me to read 95. It is submitted that it is startling that few states opposing the reference place considerable reliance on the judgment in Nabam and read numerous paragraphs of the said judgment and specifically place reliance on paragraph 147, 148, 149, 153, 154 and 155 in order to advance the argument that the governor does not have discretion while dealing with matters concerning Article 200. The said portions of the judgment were also relied upon in order to interpret Article 163, subclause 2. The reliance of the other side on the above stated paragraphs in the judgment in Nabam Rabia and the conclusions drawn therefrom is A, wholly incomplete, and B, a clear attempt to mislead this honorable court. While the above stated paragraphs of the judgment state that there is a limited area in which the governor can exercise discretion, the said judgment itself, while making the said observations from para 147 to 155, specifically at para 151 and 152 notes that as far as Article 200 is concerned, specific reference of 200, the governor can exercise the said power in his discretion. There was a similar incomplete reading before the two-judge bench in Tamil Nadu case by the petitioner. At paragraph 301 in Tamil Nadu judgment, the Honorable Court was led to commit the mistake by skipping or omitting the most relevant paragraphs in the same context. The state government is supposed to be a virtuous litigant and should avoid skipping or omitting the most relevant parts. Lord, please see 155(3).
No, you say that specifically at paragraph 151,
Yes.
and 152, where are those paragraphs?
My lord, next page, my lord. Next page, my lord. 151, my lord.
Yes.
The important observations your lordship gets.
Yes.
The important observations in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. A relevant extract of the same is reproduced below, and thereafter please see the bold part. But the entire thing, my lord, is dealt with, but for paucity of time, I am reading bold part. The governor's discretionary power are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of the chief minister, etc., etc. We are of the considered view that the inferences drawn in Justice M.M. Panchi Commission report extracted above are in consonance with the scheme of functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of the constitutional interpretation. My lord, if your lordship would, my lord, kindly note, I don't wish to read.
That sentence is preceded by an observation that the governor's powers are not unlimited, but restricted.
I'm sorry, my lord. My lord, I'm sorry.
So you want to refer to this, that there is a specific reference to Article 200.
200, specific reference to discretion, the constitution power to withhold. There is a specific reference, and the court says that we endorse this view. This was not read, and if your lordship were to read para 301 of Tamil Nadu, my lord, this is not placed before the court, and here also it was not placed.
Trying to take us to that judgment.
Pardon, lord?
Place the relevant portions of the Nabam.
So that's this Navam.
No, I know.
No,
No, I'm sorry, man.
Navam Rebia doesn't say
No,
there's a power to withhold. Navam Rebia does not say that there's a power to withhold. Navam
Please,
Rebia is not dealing with 200.
Please, sir, why are you
Say
agitated?
that.
I'm
Don't say
making
Naman
a
Rebia says there's a power to
constitutional
withhold.
interpretation. You are unnecessarily.
You are saying Naman Rebia says there's a power to withhold.
No, I
Naman
Lord, I will
Rebia
not
does
enter
not say
into
that.
this tutu meme. You are doing.
Make statements
I'm
like
making, my lord, a constitutional interpretation. My lord, it may not be suitable to their
Not
interpretation, my lord.
You made a
May not
statement
suit.
which is wrong.
1, 2, 4. Anyway, my lord, I'm not.
Anyway, Mr. Solicitor, the entire judgments are on record.
Your lordships may.
All the judgments are. And
Your lordships,
when I came here in 2019, it was difficult to cope up with the speed of the lawyers. From first line of the judgment, they would read to the 10th line, from 10th line to 20th line. Then we had to read the judgments, entire judgments at home. So this is nothing new here. It's a,
by now we are well used
we are
to it.
very well used
Earlier
to.
method was that the poor was appearing for the appellant will take the court to judgment
This one
after
out.
judgment after judgment.
With an exception of the.
I read it.
Read this paragraph also. So you have read entirety of judgments and then moved on till the other side. Nowadays, only
Huh,
courts
your
and
lordship, correct.
courts and-
With,
But
both
in
sides.
this case, I read it,
With-
saying
with
that
an
it was not read before the.
With an exception of
system
Justice
that you have
Narasimha, all four of us must have found it very difficult in the beginning
My lord,
to adapt to the
5 of us.
practices here.
My lord, your lordships can say on this side.
My
we also.
brother, Justice Tandurkar must be yet,
He's still groping.
My lord, I have also come to this.
from first line to, somebody would go directly to the 10th line of the judgment, from 10th line to 15th, from 15th
And
to
I think
20th,
practice-
and we are lost.
Practice in all the high courts is first the paragraph containing the facts
Exactly.
will always be read. So as to understand the
Understanding
context,
what context the observations are made.
Yeah.
only to understand the
But my
context.
lord, just my lord,
When-
be clear on my part. When I started with this matter, my lord, I did.
We are not on
Yes,
individuals.
We are
your
not
lordships
individual.
are.
Practice,
Only
practice.
Well, let us leave it at that. Let us leave it at that. Now, my lord, next question.
At least your next generation, we should make them clear that they should not adopt this technique of reading.
Yes,
Maybe because of time.
your lordships are absolutely right. Absolutely right.
Go back to the system.
And multiple will.
But in Samsher Singh, there was another, my lord, thing. Justice Krishna Iyer's judgment was read as concurring judgment. I must say, Justice Krishna Iyer does say it's a concurring judgment. But it is partly a dissenting judgment or a minority judgment. But this happens, my lord, many a times, my lord, that broadly the judge, the unlearned judge says that, my lord, once I had that experience, my lord, in a very sensitive case where me and Mr. Sibal were on the same side, when the pronouncement started that the bench is broadly in agreement, and I lost 2 heartbeats. And thereafter I realized that it was 3 versus 2. So sometimes, my lord, that happens. Lord, please see Justice A.N. Ray, my lord, the majority view, according to me, my lord, and concurring but partly minority view. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, please see, my lord, it's not exhaustive list. My lord, throughout your lordships have been very careful that these are illustrative because we do not know what contingency would arise. Reading further, to illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union, so and so, your lordship,
Yeah, this we already read.
come to 56. My lord, the bottom, the broad, my lord, the bold part. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Now, my lord, come to Justice Krishna Iyer's judgment. Here, my lord, I may be pardoned, my lord, if I skip some words, because I may not be able to pronounce many of them. Because of language issue, my lord, not for any other reason. Kindly see, my lord, from the beginning and then the highlighted part. We declare the law of this branch of our Constitution to be that the President and Governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional circumstances.
Situation.
Yeah, yes,
Situations.
situations, without being dogmatic or exhaustive. Then again, my lord, Justice Krishna here also says that this is not exhaustive. These are illustrative. Please, my
Never
lord,
be exhaustive. It can never be exhaustive.
cannot be. My lord, they other side, my lord, other side, my lord.
They also did not say it is exhaustive. They only said that wherever the certain provisions of the Constitution, either directly or by implication, have provided for discretion, there only the governor can exercise the discretion. The power under 163 does not fetter him with an unfettered discretion.
My lord,
And that also appears to be from Dr. Ambedkar's speech. But Dr. Ambedkar said that it is too premature to argue to dilate on that point, because hereinafter we will be considering the provisions wherever a discretion is vested with the governor. And maybe we can take this article for reconsideration after that, but somehow it never fell for reconsideration.
I'm not, my lord, joining issue. Your lordships are right. But why I am emphasizing this is this. The state of Karnataka's written submission as well as oral submissions, written submission para 21 specifically says that only, my lord, I'll just read, my lord, it's a short para from the written submissions, your lordship need not open. Thus, the governor is bound by ministerial advice in the discharge of his functions. Article 163 requires the governor to act in his discretion by or under the Constitution only, bold, underline, in the following circumstances. Then articles are quoted. And, my lord, it must have missed their attention, my lord, I believe. Article 164 and 174 not quoted. Summoning of the assembly, calling upon the chief minister to prove his floor, it's not quoted. Because they say that only where it is provided under the Constitution, there is a discretion. Therefore, my lord, they treat these instances as exhaustive. I'll complete this. My lord, please see, my lord, Justice Krishna Iyer's minority view, my lord, though which my lord, his lordship says it's a concurring view, but this part, my lord, is not in tune with the majority. We have no doubt that the Smith's statement, so and so, regarding royal assent holds good for the president and governor in India. This is contrary to the majority view. The refusal of the royal assent on the ground that the monarchy strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency or possibility, or possibility, or possibly if it was notorious that the bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of the assent. Look, this is not what the majority has said. In what I have quoted, my lord, in para 54 to 55, 56. This part is a discordant note by Justice Krishna Iyer. That's all. Now, my lords, may kindly come to Lord. Lord, I have already told you, my lord, assisted your lordships by saying that all judgments which I have quoted here say that these are illustrative and not exhaustive, which were read, sought to be read as exhaustive, my lord. So I'm not, my lord, going into it. Lord, now I come to, my lord, my second last point, my lord. That is, no mandamus can be issued to the governor or the president. And Article 361. My lord, this, my lord, I may take, my lord, 10 minutes. And, my lord, there is, in my submission, my lord, a direct judgment in A.K. Roy, where, my lord, this issue is considered. The question is, my lord, there are three categories of cases your lordships are dealing with when the governor's power is concerned. The first is purely executive power, namely the power under Article 356, etc., the power to grant pardon. That is, my lord, first case where your lordships have said that we have the power of judicial review. My lord, please don't treat this as an argument of arrogance that you cannot go into it. It's an interpretation that this aspect is non-justiciable. That's as a constitutional proposition. Your lordships have said that even in cases of 356 or in Shatrughan Chauhan, your lordships have said the power to grant pardon within a particular time limit, etc. The judicial review is read, though very, 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 very restrictively. Second category is, my lord, category like Article 200 and 201, which is legislative in nature, my lord, which I have already pointed out. Now, please come to, my lord, page 793. Para 112A. The issue of justiciability of precedents and the governor's exercise of functions under Article 201 and 200 respectively must receive a nuanced interpretation and must not be conflated with usual principles of judicial review. The question of denial of assent to a bill or the action of the governor to refer the bill to the president is not akin to or comparable to the exercise of his executive powers, such as pardon or imposition of precedence rule. Apart from being qualitatively different in terms of the functions, the following factors need to be considered. The suggested exercise of judicial review in case of Article 200 and 201, unlike other instances, involves three steps. Prescription of a timeline. 2. Quashing of a decision of the governor to withhold assent or quashing of a decision to refer the bill to the president. Quashing the decision of the governor to resort to first proviso instead of choosing either of the three options in the main part. And 4. A direction to withdraw the reference made to the president or returning a bill. My lord, these are the four possible contingencies your lordship will have to resort to if your lordships were to exercise the power of judicial review and make this decision making justiciable. My lord, 113. In none of the cases involving the exercise of power by the president and the governor has this court ever imposed a one-size-fits-all time frame, dehorsed the nature of the action and its complexity. Each case turns on its own peculiar facts. Now, please, my lord, read, and this is very, very important judgment, not cited by my lord, anyone so far, on justiciability. Lord, this is A.K. Roy versus Union of India. It's a constitution bench judgment. We may now take up for consideration the question which was put in the forefront by Dr. Ghatate, namely that since the central government has failed to exercise its power within a reasonable time, we should issue a mandibus calling upon it to discharge its duty without any further delay. My lord, kindly pause here for a minute. I'll just give the brief background. My lord, Justice Surekant, my lord, was right, my lord, that fact situation will have to be given. In case of Article 200, the legislative process commences from introduction of the bill and ends with Article 200. It's a part of legislation. This was a case where a bill became an act, but the government did not notify it because it becomes effective only when the central government,
There are many acts which will come into effect from the date on.
from the date of it is notified.
Official notification in the
Notification.
official.
And government was not, my lord, doing that, government of the day. And therefore, my lord, a writ was filed that direct the government to notify the act, meaning thereby to bring the law in force. Grant of assent also brings the law in force. This also brings the law in force. And therefore, my lord, I am reading this judgment. Our decision on this question should not be construed as putting a seal of approval on the delay caused by the central government in bringing the provisions of Section 3 of the 44th Amendment Act into force. I'm sorry, not even law. Even the constitutional amendment was not brought into force. Article 22. I am thankful to my learned. That amendment received the assent of the President on April 30, 1979, and more than 2.5 years have already gone by without the central government issuing a notification for bringing Section 3 of the Act into force. But we find ourselves unable to intervene in a matter of this nature by issuing a mandamus to the central government obligating it to bring the provisions of Section 3 into force, even to the government. In my respectful submission, the threshold in case of the Honorable President and the Honorable Governor would be high.
But then the next sentence is more important.
I'm reading. I would not skip anything. The Parliament has left to the unfettered judgment of the central government the question as regards the time for bringing the provisions of the 44th Amendment into force. It is not for the court to compel the government to do that, which, according to the mandate of the Parliament, lies in its discretion to do when it considers it opportune to do. The executive is responsible to the Parliament, and if the Parliament considers that the executive has betrayed its trust by not bringing any provision of the amendment into force, it can censure the executive. It would be quite anomalous that the inaction of the executive should have the approval of the Parliament, and yet we should show our disapproval of it by issuing a mandamus. The court's power of judicial review in such cases has to be capable of being exercised both, please mark this, positively and negatively. And I'll say, my lord, why I'm requesting your lordships to mark this. If needed, it has that power positively by issuing a mandamus calling upon the government to act, and negatively by inhibiting it from acting. If you have the power, you have power of both positive as well as negative. If it were permissible to the court to compel the government by a mandamus to bring a constitutional amendment into force on the ground that the government has failed to do what it ought to have done, it would be equally permissible to the court to prevent the government from acting on some such ground as that the time was not yet ripe for issuing the notification for bringing the amendment into force. We quite see that it is difficult to appreciate that practical difficulty can possibly prevent the government from bringing into force the provisions of Section 3 of 44th Amendment after the passage of 2.5 years. But the remedy, according to us, is not the writ of mandamus. If the Parliament had laid down an objective standard or test governing the decision of the central government in the matter of enforcement of the amendment, it may have been possible to assess the situation judicially by examining the causes of the inaction of the government in order to see how far they bear upon the standard or test prescribed by the Parliament. But the Parliament has left the matter to the judgment of the central government without prescribing any objective norms. That makes it difficult for us to substitute our own judgment for that of the government. Government on the question whether Section 3 of the Amendment Act should be brought into force. This is particularly so when the failure of the central government to bring that section into force so far can be no impediment in the way of Parliament in enacting a provision in the National Security Act on the lines of that action. In fact, the ordinance rightly adopted, no, that's on facts. It is for these reasons that we are unable to accept the submission that by issuing a mandamus, the central government must be compelled to bring the provisions of Section 3 of 44th Amendment Act into force. My Lord, now this is followed in these two judgments which I am not reading, but please see, my Lord, the position which will emerge. My Lord, and in a different context, my Lord, Justice Narasimha, my Lord, did, my Lord, indicate that. My Lord, kindly, my Lord, examine this. I'm saying it, but what it means now. My Lord, kindly appreciate, my Lords. And I'm sharing this concern because your Lordships would be deciding henceforth what will be the course of action. My Lord, the 5-judge bench says that the power includes positive as well as negative.
Negative. No.
Do something.
No, the court rejects the prayer on the ground that if we hold that we have a positive power, then we also have a negative power to withhold the central government from enforcing
No.
the legislature.
No, my Lord. No, I'm sorry, my Lord.
Yes.
Court says that if we have the positive power to direct them, we also have, if we have negative power to prevent.
This has been observed while rejecting the prayer for issuance of mandamus.
Exactly, that's what, my Lord, I think, my Lord, I'm saying the same thing. I am unable to, my Lord, articulate the way your Lordship, my Lords, are doing it. I'm saying the same thing, that if I have the,
And
if
the judgment goes on further to say that if the Parliament had prescribed some objective criteria that, like on happening of such and such thing, the executive may enforce the act, then maybe we would have been justified. Such and such circumstances exist, and therefore the Parliament should now.
I bow down, that's my submission.
But since the Parliament has left to the exclusive discretion of the executive
We cannot die.
as to when an act
Your
will be
Lordship,
enforced
sir,
or
right,
not.
my Lord, I am respectfully submitting that only. Now, my Lord, visualize the situation. My Lord, the judgment of this court, my Lord, in Tamil Nadu says that if the president doesn't decide within 3 months or the governor doesn't decide within 1 month, you come to us. Correct, my Lords? Now, state comes before your Lordships. The prayer would be direct him to grant an assent. The question is, can that be done, my Lord? Can a writ of mandamus be issued to either the Honorable President or the Governor to grant an assent? But the problem doesn't stop there. My Lord, somebody moves an application or files a separate petition that no, prevent the Governor from granting an assent and refer it to the President because there are repugnancies. The 2 petitions will be listed before your Lordships. There can be, my Lord, some MLAs who will file a separate petition that no, prevent the Governor either to grant an assent or refer it to the President, but ask him to return it to the House, because when the bill was passed, the Chief Minister was enjoying the majority confidence. Now we don't want that to happen. My Lord, would your Lordships be in a position to substitute what options the Governor would exercise? If your Lordships have the power of granting a positive mandamus, that do something, your Lordships can also say that don't refer it. to the president. Don't return it to the house. Don't withhold it. So therefore, quite climate actions, my lord, are not permissible, and therefore, my lord, this exercise is non-justiciable. Lord, that is my respectful submission. Otherwise, my lord, your lordships, it's not the state government only which can come. Citizens can come. Member of legislative assemblies can come. And, my lord, as it is, my lord, happening.
The qualitative difference between the two situations.
Hmm.
There only the executive have the power to notify when an act comes into force. This situation, there is a question prior to that, that whether there is such a power with the
Therefore,
government.
threshold will be more.
The governor.
It's
has
a
the
greater
power of withholding. So it depends on that answer. Suppose we hold he has no such power, then mandamus will not arise. Suppose we say that he has no such power, then obviously it's a different situation.
No, correct, my lord. My limited point is, my lord, would it be possible for this honorable court, apart from being, would it be permissible to deal with such situations where there are 4 petitions raising 4 issues? One says grant assent, one says don't grant assent, one says direct him to refer it, one says direct him to return it.
There is a difference in situation, Mr. President.
Yes, my lord.
Requesting the governor through a direction, through a writ of mandamus, that you please take a decision within your prerogative under Article 200 is something different. Asking the governor to take a decision in a particular manner is altogether different. The power to issue a writ of mandamus.
Approved by the intervener. Your lordship's view is approved by the intervener.
Why?
That
He says
both sides
yes,
will
correct.
approve. Both sides might approve it.
Or the 3 sides. So he said that he will,
He is no side, my lord.
no,
He is
he said
intervener.
that he will be laying down a middle path.
No, he didn't lay any path, my lord, but is not definitely middle. Anyway, my lord, let's not go into. The lordships are right. But, my lord, question would still be, and forget, my lord, this matter or reference, would one constitutional organ issue a mandamus to another coordinate constitutional organ when there is there is a discretion available, when there are 4 options, where there is no time limit prescribed by the constitution, though otherwise time limit is prescribed.
Howsoever high one be.
Yes, my lord, that applies to all 3 organs. I bow down.
So, as a custodian of the
My lord,
constitution,
Lord, I'll not go into that debate, my lord. That's not a, my lord, very, this is not an occasion.
we also have, we always say, I publicly say that I am a strong believer in the doctrine of separation of powers. And though the judicial activism has to be there, it should not turn into judicial terrorism and
Judicial adventurism, as your lordship say, my lord.
at
Yes,
the same time,
correct, my lord.
if one wing of the democracy fails in discharging its duties, would the court, which is a custodian of the constitution,
My lord,
be powerless and required to sit idle with
Lord,
folded
I
hands?
have already made my submissions on that. I have also cited a judgment when a law, because let us be very clear, not only court, executive is also a custodian of fundamental rights of the citizens. The legislature is also a custodian of fundamental rights of citizens. Everyone, all 3 organs. I have cited a judgment when the law was sought to be made that court is not deciding dispute. Please don't take it as an, Lord, it's a constitutional
we are willing to listen to all the arguments.
Yeah, yes.
Yeah.
So, my lord,
That
my
we have no
respect.
power, we have no, we have no quarrel with that proposition.
Yes, yes.
But then we are just.
Lord, my respectful submission is, my lord, that issuing a mandamus with regard to a legislative discretionary function of a coordinate constitutional functionary would violate the theory of separation of powers. And in my submission, this separation of power is a part of basic structure. My lord, I leave it at that. My lord, now, my lord, I come to, my lord, page 808. my lord.
What?
08. Not as soon as possible. I'm sorry. Pardon me, yes. No, as soon as possible. At the outset, my lord, I make it clear. My constitutional interpretation, with whatever limited understanding I have, is that as soon as possible cannot mean endlessly. There is no doubt or dispute about it. For which, my lord, and your lordships very rightly, my lord, prevented me from giving the empirical data. But since last 50 years, assent of 90% plus bills are given in 1 month. Even in case of state of Tamil Nadu, except these few disputed bills, the assents are given, Lord, at least we have the data from 2005 within 1 month. It cannot be, Lord, that the governor has a power to sit over the bill endlessly. That's not my respectful submission. Lord, the purpose by which the Constitution uses the expression as soon as possible is, my lord, this. Lord, every bill has its own context-specific issues. Sometimes it might need, my lord, consultation and collaborative exercise with the executive. Sometimes, and my lord, your lordships may, with my lord's experience, longer experience both on this side and that side, would, my lord, also appreciate this, my lord. Sometimes, because of a popular public perception, despite knowing that this bill may ultimately harm the state, the legislature is required to pass it to calm down the situation. And there are instances, my lord, I don't want to go into the facts, where the executive requests the governor that we have passed it, but you please hold your hands till the matter is cooled down. Sometimes the governor himself may feel that this is something so drastic which is taken because of peculiar fact situation. If I wait for 2 months, maybe the situation might change and I'll be able to persuade the government to either withdraw or to make some suitable modifications. Look, there are a large number of such contingencies. And it is that, Lord, constitutional collaboration and consultative process which has worked successfully. Imposing 1 month and 3 months time limit would be self-destructing, apart from being not permissible under the Constitution. That leverage, that discretion shall have to be in the larger interest conferred. While saying that as soon as possible does not mean perennially sitting over the bill or sitting over it for 3 years or 4 years. There may be, my lord, good reasons to wait for 6 months. They are in discussion. Whatever, my lord, I don't want to multiply, my lord, the situations or exigencies. But there can be, my lord, a possibility that this straitjacket timeline, my lord, may not be a permissible, my lord, way of. And, my lord, there are several bills which, by its very nature, is required to be assented to on the next day. Why even 1 month or 3 months? So that is, therefore, my lord, the Constitution says as far as possible. As soon as, I'm sorry, not as far as possible, as soon as possible. It was a inadvertent error. As soon as possible. So while not taking, my lord, an extreme position that perennially sit over it, but I'm saying that it depends upon the fact situation, and please leave it to the constitutional wisdom of a coordinate constitutional functionary rather than binding him that you do it within 1 month, and if she doesn't do it, come to us. That may perhaps not be, my lord, the constitutionally correct course of action, my lord. And, my lord, I have given the judgment, my lord, they relied upon constitutional silence. That constitutional silence can be filled in. Lord, this is a conscious constitutional choice of words. Constitution is not silent. And even if it is silent, I would, I really, my lord, sometimes feel handicapped, my lord, that why I did not learn the lip reading, my lord. sometimes we can only, my lord, apprehend or, my lord, anticipate what must be going on the lighter side. Nothing turns.
We had a senior colleague at Bombay High Court. When the arguments were going on, he used to do paintings.
He drew paintings. That's the worst compliment a lawyer can get, man. Compliment a lawyer can ever get, that
Or a judge.
or a judge. Your lordships are right. Now, my lord.
He was into painting, carpentry, everything except
Judging. Lord, I'm not reading, my lord,
Yes.
but this is not a constitutional silence. This is a conscious choice of words and a conscious call to leave it to the discretion. I'm not reading the judgment. Number 3, this is not a Vishakha situation where your lordships would thereafter supplement something. Even if there is a silence and silence is required to be cured or corrected, the remedy would be Article 368 for the Parliament to prescribe time limit with some manageable standards, with some condition or whatever, my lords.
like we have done in Telangana.
Yes, my lord, I have reservations about Telangana view and Punjab view.
No. Telangana speaker's judgment.
Yes. My lord, that was.
We have held that it is for the Parliament to decide whether the speaker should be.
And another thing, my lord, he's a tribunal. My lord. Suppose some decision is to be taken, my lord. Suppose the governor is also a vice chancellor or chancellor. He is supposed to take a decision within 2 months. Or no time period is prescribed. Your lordships can issue a direction because he is acting in his executive capacity, purely administrative capacity. Therefore, my lord, wherever the Constitution has used some words or chosen not to use some words, it's a conscious constitutional choice. It's not, my lord, a silence which is required to be filled up by a judgment. So, my last submission. My lord, what now, my lord, after, my lord, if suppose, my lord, our submissions are find favor with your lordships, either fully, partly, whatever. The argument which was again, my lord, a very extreme argument was that you can do nothing about the Tamil Nadu view. I'm not on the judgment. Intra-party, the judgment is final. That's the law of the land and binds, my lord, us. I cannot argue contrary to it. But your lordships has the jurisdiction and power to declare that Tamil Nadu judgment is not the correct law. And that is what, my lord, as a last proposition, my lord, I wish to, my lord, submit. My lord, please come to page 816. My lord, I read it, my lord, but there are 2 or 3 paragraphs and I would wish to, my lord, reread it, my lord. Main emphasis, my lord, your lordship said, 816. Well, this is a 2G judgment, where your lordships would, my lord, remember, in the questions which were referred by the Honorable President, one of the question was whether this particular judgment of Justice so-and-so and so-and-so is a correct law. The court says intra-party we cannot go. My lord, that background in mind. Para 45.
The reference, Manoj, I don't want to object, but this is not part of the reference. This is nothing to do with the reference. Judgment is not
Mr.
even referred to in the
Sipal Saab,
reference.
you
I'm
please
just
take instructions.
part of the reference, that's all.
Lord, I'm making this submission with responsibility and understanding what I am making.
But is there a question framed to that regard? So he'll be only
Mr.
answering.
Datar has said that you cannot touch the law laid down.
That is not a question which is for consideration before us. We will be only answering What are the questions that are referred to us?
What
What
my,
will be the consequence of our judgment? That's the
Lord, what
consequence
Mr.
of
Sibal did was,
acceptance.
what Mr. Sibal did was,
That
when
He
he,
is giving our opinion.
That-
only give me a minute, give me a minute.
So that somebody else may decide what is the consequence of our judgment.
But it's not, well, something, my lord, I am saying it with a sense of responsibility. He rightly objected at a right time. My lord, when he could not raise these objections, my lord, at the outset, when the preliminary hearing was going on, he said, look at this question, cannot be answered. Look at this question, cannot be answered, and re-raise preliminary objections. Mr. Datar specifically said, law laid down by Tamil Nadu judgment is the law of the land, and you cannot touch that law of the land, and I am entitled to respond to it, my lord. Please allow me, my lord, to read only 2 or 3 paragraphs of 2G judgment. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri judgment, which according to him prohibits this court from overruling a view expressed by it previously under Article 143(1). We are not persuaded to agree with the learned counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of the court, whereas in the subsequent sentence, he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these two situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draws a difference between the two by using the word when further this court overrules the view of law after discussing the decision. My lord, kindly turn the page over. 817 and bold part. After the exercise of those limited options, the parties concerned have absolutely no relief with regard to the dispute. It is considered settled for eternity in the eyes of law. Lord, between Karnataka, Tamil Nadu and Union of India, for between and governor, for those bills, it has attained finality. Please see this. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced by the court of reaching the decision. Justice Sawant in so-and-so clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power. When he says, then, my lord, it is quoted. This is a judgment in a reference with while dealing with a contention that judgment and the view expressed
So
cannot
according-
be touched.
Whatever we hold may not be applicable to the matters
Those bills,
covered by-
yes, yes, yes,
matters
yes.
covered, But the law would be what we hold. And
Yes,
would be applicable
it's
hereafter.
not just, my lord, as said, it's only a report. Your report, your lordships are not a reporting authority to the president. It was, my lord, unfortunate that such a word was even used. The honorable president has sought your lordship's constitutional interpretation, and your lordships are, my lord, giving the advice to the president. It's not just a report. And your lordship's inherent power, my lord, that's what the court says, can permit your lordships, my lord, to even overrule the view expressed while maintaining the decree intra partes. My lord, last at the foot, my lord,
Actually,
the
in any
highlight.
case, the judgment of view taken by 2 judges on law would not be binding on the constitution.
The argument was it is binding because
On fact, inter-party.
yes,
that
yes,
judgment
I'm
will be
not
binding.
on that. But argument of Mr. Datar was that is a law and therefore it binds even the advisory jurisdiction of this court. And your lordships cannot touch even the view expressed. My lord, kindly see the last line, last highlighted part. In fact, the overruling of a principle of law is, my lord, please see, my lord, page 817, paragraph 48.2, the highlighted part. In fact, the overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. The argument was that if you overrule the view of law, you will be sitting in appeal over the 2-judge bench judgment. Court says, no, it's not appellate jurisdiction. It's our inherent jurisdiction. This inherent power can be exercised as long as a previous decree vis-a-vis lists inter partes is not affected. for those bills, my lord, that is final. My lord, somebody can, my lord, take a remedy whether there is repugnancy, not repugnancy, etc. Your lordships would not go into it. But your lordships can say, and in my respectful submission and prayer, that please say that that's not the correct law which is laid down. My lord, last point, my lord. My lord, I have dealt with all, my lord, the submissions of my learned senior friends. But only one submission was made by the intervener, my lord. I don't know, my lord, what was the purpose, but he relied upon Article 374 that federal court judgment is binding. I don't think, my lord, your lordships would be going into that because the federal court judgment is being binding or not. But there is a judgment of your lordship saying that federal court judgments are not binding to the Supreme Court of India. Direct judgment, quoting the very provision, my lord, which was relied upon by the intervener. I don't think, my lord, I can go, but kindly note, my lord, if your lordships are taking note of that, because he relied upon some federal court judgment and said that you cannot examine the reference, etc. And, my lord, this is 1991, volume 4, SCC 406. And paragraph 32,
1991.
1991, 4 SCC 406. It's a 3 honorable judges, Justice Kuldeep Singh. My lord, it's on record. 4584. My lord, I knew somebody would raise this issue. 4584. My lord, para 32. My lord, it's a long para, but it deals.
48, volume?
511, my lord. Volume 511.
Page 48,
I'm sorry, the relevant or it's
84.
and the relevant at 4626, para 32. Mr. Nariman raised this very argument, which was repelled. That for federal, why, my lord?
What is that?
My lord, it is Delhi Judicial Services Association versus State of Gujarat.
Annexed for the Article 142 point.
Anyway, my lord, whatever. But it's not a point in consideration. Nobody has argued, my lord. At least the states have not. I am also not. My lord, 142 evolves, my lord, from the facts of each case, my lord. But that is fundamentally wrong. And if your lordship holds that it binds, that will be opening floodgates, my lord, because what happened in 1920 and whatever the law laid down in 1920, you start becoming binding. My lord, therefore, this question has arisen and is answered in the negative. My lord, I am immensely grateful, my lords. And my lord, I must say, my lord, I have learnt a lot from all, my lord, Mr. Sibal, Mr. Gopal Subramaniam, Mr. Singhvi, Mr. Datar, everyone, my lord. It's an enriching experience from your lordship's query also, my lord. Every time my lords put a query, my lord, we researched, and my lord, that was an enriching experience. But I'm really thankful for my team, especially Kanu Agarwal. We are as good or as bad as, my lord, our team. My lord. I'm grateful to everyone.
As Mr.
Right, my lord.
Gopal Kumar rightly put in, you have put in a lot of industry.
Pardon, my lords?
You have put in a lot of industry. He has complimented you yesterday.
Yes, yes. My lord, therefore, my lord, I mentioned Mr. Subramaniam, my lord, specifically right now, that I've learned a lot from everyone, my lord. I'm grateful to your lordship.
Before the age starts, there are three issues which have not been touched now. One is the dating investment. The other which follows is the parent patronage.
With regard to?
Dating investment. Dating investment, not because he is the judicial minor.
But then now, in rejoinder, how can we hear you?
He is not an intervener on this.
No, what I am only saying, I have filed written submission, Lord, in one of the ias which have been, I'm only requesting your lordship to go through that, because it has a bearing, Lord, on the answer to your lordship. That's the only submission I am. Because, why the name of the God has been brought into, while giving the oath, etc., has all been dealt with it.
That's not relevant.
Yes,
It's on this side, my lord, but
yes, Mr. Solicitor.
only one last line, my lord. One of the question framed is whether Article 32 petition would lie. We have not addressed your lordships in the, my lord. So,
No, address your 1.5 hours we have taken for that.
No, it was on justiciability and
No,
judicial.
no, no, no. Even on maintenance, we have Article 32 and 226.
So then they kindly decide.
Therefore, we have reached to up to today. Yeah, otherwise we would have concluded it yesterday.
I bowed down. There is no.
For your 1.5 hours, we had to compensate them more than 3 hours and.
My lord, that your lordships are right, my lord. That one of my 1.5 hour, my lord, cost me a lot, my lord. And your lordships a lot.
There's no question on Article 32. Your lordships can see, there's no question.
Yes.
Yes, Mr.
May I please you?
States have assisted your.
I mean, just as the learned solicitor complimented the assistance given by all the learned counsel. I wish to take you lords a little away from the focus on Article 200 for the time being.
Don't take us beyond the questions which are framed.
I
You
wish
can
to
take
be
us
little
anywhere
away
within
from it for the time.
within the framework of the questions that are framed.
Yes, yes. It's a matter of concern that we're talking about an important provision of the Constitution. And very often when we deal with such important provisions in the matter of rights, restrictions, we also land into questions of moral principles, policies, values, and they sometimes get so jumbled up that we find it very often difficult to disentangle them and to look at only the purely legal principles. Why I say this, in the course of assistance to this court on Article 200, I just want to bring to your lordship's notice a famous Greek mythological figure, Procrustes. Procrustes was a robber in some place called Attica. So he had an iron bed. And so when he catches somebody, if the person who is caught is too larger than the iron bed, he will cut his legs. If the limbs are too shorter, he will stretch his legs. So this phrase became a Procrustean bed mean to try to suit mechanically all possible circumstances so that you fits one particular way of looking at it. So both parties have tried to say, look at either stretch it or shrink it. And that's our duty to tell you, Lordship. But then 200 should not be put into a Procrustean bed. It has a life breath of its own. It is an important value in the entire scheme of the Constitution. And therefore, let us not fall into a trap of saying, for instance, I'll give a syllogism. In logic is something called a syllogism. The Constitution keeper said, keep away discretion from Article 200. Discretion figures in some other part of the Constitution. Therefore, the inference is this. Article 200 devoid of any course of action, independent course of action by the governor. So we have some syllogisms like this, like, let me give some examples. All delays are bad. Governors tend to do delay. Therefore, all governors are bad. We don't have this kind of syllogistic fallacy to assist the court. Or all hippopotamuses four legs.
What is the argument?
I'm coming to Lords. I'm trying to say that how will the court be assisted in trying to look at Article 300? So we don't fall into those fallacies to say, because looking at the Constituent Assembly debates, a certain expression or a word has been removed from it for a certain reason. The entirety, the logic of retaining Article 200 with a governor in place in Article 200, will you completely rob away the constitution makers' understanding as to why we still need a provision like Article 200? If all those debates in the assembly, discretion dropped, we have doubts about governors becoming super legislative authorities and so on and so forth. After all these debates, Article 200 still finds a position in the Constitution. The constitution makers could have probably said, we will not have governors in Article 200. We will have some other way of looking at whether, after an entire exercise, a responsible legislature has passed a law. Should we need a check on that? What kind of a check could it be? Therefore, if the constitution makers thought we still need to have some kind of a check or a scan on that, I think it's important for us that Article 200 be given its plenary understanding of not being subject to any shackles. The argument is, please keep it under control, because democracy is important. The legislative wisdom is important. All those principles notwithstanding, if the constitution makers show that the governor will play a role in understanding whether the final word on taking the law to its conclusion, a bill to its conclusion, will lie with the governor, will you say, I will shackle his hands and say, therefore, I will impose as many restrictions as possible so that nothing remains for the governor to make an independent choice in the four options given to the governor? But that's a fundamental question. You're being asked, you're being told that, please limit, constrain it, impose as many restrictions as possible. I would say, please don't do that. All the set of questions are framed on the understanding, please allow a certain amount of independent exercise of judgment by the governor and the president under Articles 200 and 201. That if at all there is an importance of having a scan at a particular point of time before a bill can become a law, please allow it to remain as it is. The moment you say, no, I will exercise a judicial power to say, how will you articulate your power? How will you exercise your independent judgment? Then you are entering into not only rewriting the constitution, but you're entering into opening up a whole range of a new, what you will call a new jurisprudence on governor's assent. The endless exercise and involvement, engagement of what the court will do and what court will not do, who can ask the court to do what, all those questions, justiciability, jurisdiction, maintainability, writ petition, all that will come in. You can't stop it. No court can stop it. We are lots to give an illustration about fixing timelines on medical college admissions. So once you open up a certain things for a certain consideration by the court, Dworkin used to call about judges that they are not deputy legislators. So once all this happens, the court will become something like a deputy legislator, stepping into the shoes of the governor or the president, as the case be in some case or the other. So you're talking about that importance of the subject. The president's reference questions are based on this understanding, namely, whether we have a Tamil Nadu judgment which has certain difficulties or not is not the question. Therefore, right from the Special Courts Bill, this court has said, if a judgment has to be reconsidered, it will certainly be reconsidered. It will not be overruled in the sense by an adjudicative process, because it is not the correct view of law, which will enable party, legislature, executive, parliament. So that's how it has to be seen. That's my larger say on the relevance of the reference. Then I have some questions on how will you therefore look at Article 200 itself. I'm not going to take a lot from the text of the provision. But before I do that, I think it's important to invite Lord's attention to a very several observation made by Justice Holmes in a dissent in a 1907 judgment. That is in the context of hard cases. I just propose to read that. If I will also take my supplementary written submission. Paragraph. It is volume 1.11. Paragraph 38 at page 902. Because there are too many statements have been canvassed here saying, generalizing several propositions about judicial review. So kindly turn to that, page 902, paragraph 38. That entire dissent is very instructive, but I'm only extracting one important part of the dissent. The voice of dissent in so-and-so is worthy of consideration. Great cases, like hard cases, make bad law. For great cases are called great, not by reason of their real importance in shaping the law of the future, but because of some accident of immediate overwhelming interest, which appeals to the feeling and distorts the judgment. That's precisely what happened in the Tamil Nadu case. You pick up a certain bill. I'm not playing with judge view on that. I'm only saying, say that what an immediate overwhelming interest which appeals to the feelings and distorts the judgment. These immediate interests exercise a kind of hydraulic pressure, which makes what previously was clear seem doubtful. For more than 75 years, governors were sending within 1 month. A 0.8% is what you're talking about. So what was clear seemed doubtful, and before which even well-settled principles of law will bend. I wish your lords apply this very instructive advice to look at why the president before a lot on this question. We just, in the way I understood, since I appeared in the Tamil Nadu matter, we've been canvassing a link between the withholding of assent principle or the option and the first proviso. I think there is some fallacy in linking that. When the governor thinks I want to withhold assent, with or without reasons, I'm not getting into that question. It's communicated, it's declared and all that. But in the first proviso, it's something else. The first proviso, in my understanding, and that's why it will make a sense if I put it like that. The governor is inclined to give assent. He's not withholding assent. He's inclined to give assent. But he says the bill can be improved. He doesn't lack the authority to make that improvement. Therefore, it says in his opinion, when he is not inclined to withhold assent, therefore, as soon as possible, the bill is good. I'm going to give assent. But I want to tell you, I'm sending a message giving some recommendations. Recommendation for what? For improving the bill. In my understanding, it will do well. Please consider my recommendation as far as making the bill different. So when my recommendations are not accepted to, that's why in the rules, all the business rules, the house rules say there will be a discussion, deliberation, a vote on the recommendation given by the governor. There will be a full-fledged deliberations in the house. So when the recommendations are not found favor with the house, then they sent it back. The governor, now that he is already inclined to give assent, he will certainly give assent. He will then not say, I will withhold assent. That's how the first proviso must have to be read. He is giving a recommendation to the House Assembly, says, please consider my suggestion to make the bill or the bill look better or different. It can be any kind of recommendations, effective recommendations. Therefore, in order to say when he is withholding assent and he is sending it to the House, and when the House reconsiders it, his hands are tied, I think is a very narrow way of looking at the first proviso. First proviso operates in an entirely different situation. Therefore, we are talking about the 4 options. Otherwise, it is sunk into only 2 options. I withhold assent, send it to the House, then House says no, everything is over. The only doubt which, of course, is bothering the court and all of us here is, Valluri Basavaya, Nambudiri, all that series of judgments says the bill will fall through. And whatever one would like to ascribe to that. The presidential reference questions are framed in this context. If more than one constitution bench judgment says the bill will no longer be a bill which is alive, some other action will have to be undertaken by the House or the executive or the governor, then of course they will undertake that exercise. But to say that I want to give a different meaning to this large line of reasoning, then of course we have a problem. That's why the president's reference says, I have so many judgments on my table. Which is the correct view as regards how will the governor exercise an independent judgment? How will the president exercise an independent judgment? That is why the president's reference questions looks at all this, including the Tamil Nadu judgment. It is not an attack on the Tamil Nadu judgment. It's a question of understanding what will probably the best view of looking at Article 200. So what will be the view of law? So the reference is entirely based on soliciting an opinion from this court on what will be the view of law on Article 200. If at all, it must continue to remain an important part of the constitutional scheme. If one has to close the eyes to the scheme of Article 200, then we don't need it at all. Instead of, therefore, if the court were to say, I would therefore, with my pen and paper, I said so in commencement of the argument. With a pen and paper, you will say, I will write Article 202 in the following manner. It will look better. I don't think that's the role of the court assigned to make a article, provision of the article look better. I can understand a court talking about a rights determination, whether right to privacy, commercial speeches, speech, etc. Then you are talking about rights, adding meaning to certain words in the Constitution to make a right efficacious. But here we are not talking about that. We are talking about expanding the Constitution in certain areas, but you can't say the same logic and tool to say, I will rewrite the Constitution because it looked better. That is the only trigger point why this reference has come before your lordships. There was a larger picture, a larger canvas is involved here. So how will the Constitution, therefore, will the court now read 200 in such a narrow way so that over a period of time, it will probably vanish out of existence? Is it not a role of the parliament to look at it? Therefore, whether the Constitution at some point of time, experience is gained, parliament will say we no longer need the Article 200. They will do it, or they will make some amendment to Article 200. For the core question is whether what has been done over a period of time with Article 200, should it remain free from all the restraints and shackles which should not be imposed upon, the only question. So all arguments advanced here is to buttress this argument, buttress this proposition. Now, I was also trying to understand, how will the governor work under the Article 200? I think, firstly, there are composite lines of reasoning. The governor will first find out whether, I'm not talking about the aid and advice proposition. I'll show the absurdity if you have to go along the aid and advice proposition. The governor will have to first find out, before he gives assent, whether I should withhold assent. Then, if it is not a question of withholding assent, if he thinks it should be sent to the president, he may examine that possibility. If both these possibilities do not exist, then he will assent. Therefore, you have to go by ruling out, like in Sanskrit we say, nethi, nethi, not this, not this. Therefore, once I rule out withholding assent does not exist, is not available, and sending it to the president is also ruled out, then automatically I'll give assent. But after I say I'm withholding assent, then all the judgments about following through will come in. That's why also, even after withholding assent, if there is a difficulty, if the genuine independent exercise of judgment by the governor says, I should send it to the president in order that on a repugnancy question, the president will have the final say. Therefore, it's the flexibility and the dynamics involved by the governor's independent exercise of judgment. I mean, how do you keep it intact? Would you keep it intact, or will say, no, we'll bring as many restrictions as possible, or the court may conceive? So this process of reasoning under Article 200, that's why I'm saying, notwithstanding all those debates in the Constitutional Assembly, we dropped the word discretion. Section 70 of the Government of India Act dropped it. From there, we dropped it. The 175 draft article, we thought we'll have something else. Notwithstanding all that, at the end of the day, if Article 200 says, I'm giving certain options to the governor to act within these 4 options, these options, then the governor has a course of action. Options are predetermined. But what will the governor do as long as the options are concerned is a course of action to be done and undertaken by the governor herself. So in the course of action, now we'll say, now I will find out which course of action is good for you. So all that we're trying to point out, Lordship, the course of action must be entirely based on an independent evaluation by the governor. That's a core, I think, function in Article 200. To compare Article 163, 361, discretion is not found here, etc., I think is completely alien argument. It need not have a place in discretion, may not find a place in Article 200. The moment there are options, and the options, the governor has given a course of action between the options, it means a different set contemplated in Article 200. I don't think we need to go into the word discretion at all. We are falling into a trap, I would say, if we want to use the word discretion in one particular way, in one context, in a different way, in a different context. I don't think we need to get into the word discretion at all. But if you want to use it, I say that it must be equated with an independent exercise of judgment by the governor within the 4 options given to him. So if English language does not have any other word, let's not worry about that. Constitution says 4 options, exercise your judgment. So having said that, sometimes happens, we talk about all this constitutional silence, very attractive proposition. Since, give me the article. Where is it? I don't propose to take a lot to extenso on reading any judgment. Judgments have been read in extenso. I only wanted to bring this very broad concerns. And I think once the broad concerns are appreciated, I'm sure the lordships will take a view as to where a line will be drawn, or the court will not say that we are not deputy legislators and to draw lines which the parliament will draw. Yeah, volume 4.30. Well, let's just put the volume 4.30, 30. It's an article.
Volume?
Volume 4.30.
There is no 30, it's only up to 28.
I'm talking to some computer, right? Give it for me. Wherever it is. Oh, how is that level in China? How will you do that? Just give me a minute, Tosh. Reasoning process. I was talking about the composite reasoning process involved in how the governor will act under Article 200. Or when it's in the context of whether it's a writ petition maintainable, justiciability before it becomes a law and all that. The court will necessarily go into the question, what reasons are good, or reasons are adequate, or reasons are inadequate. So the endless conundrum of the engagement of the court in testing the governor's independent exercise of judgment. So you can have any number of tools to say that, look here, there is a vacuum. I'll pick up the Vishaga principle, and therefore I'll lay down some guidelines. So that is it. Yes, yes. Some article. At page 10237, the paragraph conclusion. At the bottom of that. Then how do we read it? Reading that. Yeah, I'm reading software.
There is no paging, so tell us the internal paging.
Which volume?
Oh, I'm sorry. It could be page 934 of this article. At the top, you'll also have that page number.
Are you referring to, Mr. Attorney, are you referring to this article, the general principles on constitutional law?
Which page you're asking? I'm sorry, Lord.
Are you referring to the article of the general principles on constitutional law in the United
No,
States?
there's silence. There's some article. I think not what is textual? That is true, but where is it?
It says internal page
It's been
934.
uploaded. The soft copy, I think, has been uploaded.
Internal page 934. PDF 395.
Yes.
395.
Volume 30.
Conclusion is there on the page. 30.
It's a,
The silences of constitution.
that's right.
Volume 30 is the volume.
Soft copy volume क्या है? Volume. 4.30.
Yeah. Yeah. Volume 30.
Your lordships have that?
On.
Yes, so the lordships get it.
Yes, please.
Your lordships have it?
Yes, yes. We have the manual copy.
It's a fairly thought one, but I thought let me take your lordships to the conclusion part of it. Probably the page number at the top is 10237. The last paragraph 4 of this conclusion.
10237. Okay, all right. Right.
Your Lord, does Vikramnath has that?
Yes, I have conclusion. I was the first one to have.
Certainly, your lords are ahead of me.
ये वो नहीं.
4.30 silences of constitutions. The conclusion part you want to read, paragraph 4?
I wanted the conclusion part.
Yes.
Because it talks, it's a very interesting quote from one American called Benjamin Constant, and how the American and English experience has analyzed here.
Right.
Yes, Mr. Attorney, read it.
So why I want to place reliance on this is since I read it.
Yes.
Why I want to place reliance on this article is since we are trying to explore, is Article 200, is it a case of a silence of the Constitution? Or anything around Article 200 there is silence? Or if at all there is silence, how do we deal with that? But before I thought why I need to read it is that firstly I say that Article 200, because the way it has been retained in the Constitution, has been so retained to admit of its experience over a period of time and to leave it as it is so that we don't feel as if there are too many gaps in Article 200 and fill it the way we want it. So assume too many gaps in Article 200 is one extreme proposition. To say that Article 200 gives sufficient intrinsic guidance to the governor and over a period of time what they will do. That's why we are talking about more than 75 years now. About 98.5% bills within 1 month, assents have been given. We are talking about a very negligible percentage of bills, 0.8%, where about, as far as Tamil Nadu is concerned, about 12 bills were the controversy. 33 bills where the governor sent back with a message. I'll show you also only to a limited extent, not talking about data. So 33 bills are sent back with a message saying, what that kind of a message? In terms of my reading of the first proviso, please consider, will the bill look better with my recommendation? And 12 matters where it's been sent back. So withholding assent. So if you're talking about combining both these two distinct categories.
But I don't know, there is no difficulty if the governor sends back with a message. The question is whether he can withhold it without sending it back to the legislature endlessly.
That's why I'm trying to point out the first proviso operates entirely unconnected to the question of withholding assent. Withholding assent is an independent option, independent exercise of judgment by the governor. He doesn't have to go necessarily under the first proviso.
So according to you, he has a power to endlessly withhold it?
No, I'm not. Nobody says that. Nobody has done that. No governor said I'm endlessly withholding it.
Declare that I withhold.
Nobody has done that.
Declare that I withhold within.
So once a declaration is given, I'm withholding assent, that is the option which the governor has exercised under Article 200.
Declare in as soon as.
So therefore, I'm not even talking about, because in the first proviso, if the governor is thinking that I'm asking you to consider from a different angle, therefore I'm inclined to give assent. Once I'm inclined to give assent, why should I keep it along with me for a long period? Therefore, as soon as possible. I'm within giving assent, but consider my recommendation. He should not keep it pending with for a long time. But withholding assent stands an entirely different footing.
That has already been argued.
No, no, I'm only saying that
That has
don't
already been
connect.
argued.
Don't
It is one of
connect.
the four options.
That's why there are four options. There are four independent options.
Yes.
Try to pull them together into one or two options. I think would do violence to Article 200. So let me now read this conclusion part of it. If you're saying there is a constitutional gap or a constitutional silence, how will you look at it? The arguments advanced here. Written constitutions have become the standard instruments for establishing and regulating the governing relationship of the state. That there are silences in the constitutional text is clearly understood, though the function of these silences is less well appreciated. Sometimes they are simply to be filled through subsequent constitutional interpretations, but often they are the consequences of a conscious determination to leave unresolved certain matters on which consensus is not possible. Whatever the reason, it has been generally accepted that the Constitution establishes a framework within which and over which further political deliberation takes place. For much of the modern period of constitution making, it has been understood that the filling of these silences is a political task. With respect to which, the judiciary authority to offer solution is distinctly limited. Then I'll take a little at the farther end of this paragraph, almost at the end of the page. Silences, you lost at the bottom of the page, the sentence beginning, silences, about 10, 11 at the bottom. You lost the curve. See that? Silences that were once seen as functional, and which enabled constitutions to carry forward an uncertain political project are now being filled by lawyers through juridification and administrators through bureaucratization. When law's empire in one conception is countered by law's abnegation in the other, then a perplexing state of affairs has been reached. Some might argue that these three conceptions are ideal types that are reconcilable in the actualities of practice. But this surely works only if the framework conception of the Constitution remains dominant. We're talking about the framework of Article 200. Once the prudential aspect of negotiating those silences is no longer valued by rewriting the Constitution, and constitutional silences themselves no longer tolerated, then we will have taken a pathological turn. It means it's almost that we are aware that when you do something what we should not be doing, then we are not talking about the constitutional silence, we are talking about the silence of the grave. We're not talking about the silence of the grave. So that's one aspect of the matter. I thought, where will you look into the constitutional silences, and how you will not probably look at a vacuum and none exists, and bring in a Vishaka principle or any one of those things and say, I will look at the Constitution the best way I think it appears to me. Now, I was looking at, yes.
Footnote 35.
Yes, it is interesting. I hope I read the article in entirety. The judges will read it in entirety. In my understanding, therefore, Article 200.
Yes. Yes, because
Article 200 is a legislative process. It's a special class of legislation. While I'm not talking about pocket veto and all that, I'm not talking about it. But in the American understanding, I'll just place your lordships. No, I want to.
the learned solicitor has objections to referring to
I'm sorry, Lord.
the US or the,
Then I'm not citing any judgment.
That is my personal view,
But
not the central government's view.
yeah, but when in last 75 years, our constitutional jurisprudence is so much developed, should we again go back to the articles
But
from
I'll just make
American jurisprudence?
a little detour. But there is no aversion to foreign judgments. There are foreign judgments cited by this court, accepted by the constitution benches. But borrowing the principles, policies, ideologies, and culture and making a jurisprudence out of it is objectionable.
No, over the last 75 years, Supreme Court has developed jurisprudence.
We need not get into that question because if you lost go into it, just Anton Scalia had a great aversion to US constitutional law borrowing from outside.
No,
We're not talking about that.
Our earlier judgments
not
have
talking
excessively referred to those.
No,
judgments.
I'm not relying
Now,
on.
over the 75 years, our courts have developed our.
I don't
so
propose to
excessively
rely
so.
any judgment now. I only want to say.
More binding than our own judgments. But that should not be there. That's all.
Ullas, now, in this context about how it is to be seen as a legislative power, one paragraph in Schooley's constitutional principles, you'll also have that hard copy which has been handed over. On top, you have the rules of procedure of the House, and then thereafter we have Schooley's constitutional law.
Yes.
The running page 23 at the bottom. I suppose wherever the power to assent or approval given to bills is available, wherever they are, I think the theme must be the same. It can't be different because it's in US Constitution. It can't be different because in some other constitution. So at page 23, the paragraph beginning the veto power, Lord Chief Justice has that page? 23 at the bottom.
Yes.
Power to veto legislation which is conferred upon the president makes him in effect a third branch of the legislature. The power is legislative and not executive. And the questions presented to his mind are precisely the same as those the two houses of Congress must determine in passing a bill. Whether the proposed law is necessary or expedient, whether it's constitutional, that means we are talking about constitutional complaints, whether it is so framed as to accomplish its intent, and so on are questions transferred from the two houses to the president with the bill itself. Though in the US Constitution, the larger power, subject to whatever limitations in Article 200, the nature of the power will remain the same.
It's all missing.
I'm sorry.
But it's a procedural system.
No, that's what I'm trying to point out. When the question that will be present before the president, namely constitutional complaint. I'm talking of constitutional complaints. Here, the governor looks at the constitutional complaint.
Back to back.
Both sides. Pages missing.
US is the power. Look at the back side.
You lost it down again?
Acha. All right.
We're at 23 at the bottom.
Read the 1 minute. It says the power to veto legislation which is conferred upon the president makes him in effect third branch of legislature. Power is legislative, not executive. Read further. And the question presented to him. His mind not.
President has the power to veto and the questions presented to his mind are precisely the same as though the two houses of Congress must determine in passing a bill. Proposed law is necessary or expedient. I am not talking about that. Whether it's constitutional, whether it is so framed as to accomplish the intent and so on, the question transferred from the two houses to the president with the bill itself. Therefore, notwithstanding the differences between the scheme the US president may have under Article Section 7 of Article 1 of the US Constitution, the essential, the core essence of an assent domain is that, is it constitutional?
How does it help you?
No, why I'm talking about the constitutional compliance principle application of mine is legislative in character. It is not executive.
Therefore, if it is legislative in character, then can the president, even with the federal, with the presidential system of the governance that they have, will they observe that the power is with the legislature?
With all that well in place. With
And
all
therefore,
that
the power of veto is to
I please don't misunderstand me saying that your president is equated. US president, I'm transplanting him into governor's position. I'm not doing that. I'm not doing that.
Then here the case is worse off.
The reason
the
why
president is elected directly by the people.
no, the reason
Still
why
he can't exercise
You'll
his true
try.
power.
Can
Can an appointed governor who is not even can understand a president who is elected by both the houses?
No, that's why I'm trying to point out, how do we really look at Article 200 after all we have said the Constitutional Assembly debates? If the essential, the core function of the governor is to say, in the course of withholding an assent, what do they do? Is the bill constitutionally compliant? The constitutional compliance of the bill is a question presented to the governor. And what will he do with that question? Therefore, when he says that I will to find out his constitutional compliance, is it an executive function? The question which the governor will pose to himself or herself will be, how do I look at the...
Rather than supporting would be against you.
No, let me expose it on. The question which the governor will pose to herself will be, I look at the provisions of the Constitution. Does the bill comply with the provisions of the Constitution? Does it transgress the constitutional provision? Is there a conflict within constitutional provision? All those are questions which are legislative in character.
Whether the proposed law is necessary or expedient,
No,
whether it is constitutional, whether it is to be framed or to accomplish its intent, and so on, are questions all within the domain of legislature.
No. I'm not saying that you apply it entirely to the governorship. I'm not saying that. I'm only saying constitutionality. On the constitutionality, as far as the larger power of the president is concerned, notwithstanding, the constitutionality aspect of it is the essence of Article 200. That's why assent can be given if it's constitutional compliance.
Mr. Attorney, probably your argument is
Yes.
that from the stage of bill to before it becomes act,
Yes.
the constitutionality of a bill
Yes.
is to be examined by the governor
Yes.
within the framework of 200.
Yes.
After it becomes wherever the assent is granted
Yes.
and it becomes an act,
That's
then
right.
it becomes subject to judicial review.
That's right.
That is what
That's
probably
right.
was.
But
You're
what
saying
I'm talking about the nature. I'm talking about the nature of the exercise of power by the governor.
At that power which the governor exercised between the stage of bill to act
Yes.
is being constitutional in nature,
Yes.
is definitely better than a legislative power.
That's right. In other words,
They're superior than the
I'm a
legislative.
partnership in legislation.
That's what
Governor is a partnership in
That's the Ranit Solvency does also. The governor is also a part of the legislature.
No, Article 168 puts it for certain other reasons. You may probably incorporate and probably say something about it into Article 200. I'm not saying for the time being Article 168 is the final word. But intrinsically in Article 200, I'm trying to ask myself a question, is it an executive power or is something else? If it is an executive power, then I think Article 200 will have no value at all. I have to act
That is essentially
I tell you,
Senate solicitor that it's
under the
it's an legislative power.
No, if it is an executive power, then I think Article 200.
That has been argued at length by the learned solicitor that it's an.
No, I want to point out one dimension to it. I'm not getting into all those neat questions which have already been answered. If it is taking a leaf out of the advice of the Council of Ministers, if I am right in my submission that the first proviso is entirely different, disconnected with the withholding of the assent, I think the law will look better if my recommendations are taken into account by the House. If the advice of the Council of Ministers is binding on the governor in all aspects of the four options under Article 200, when the governor wants to send a bill to the House, I want to make some recommendations. Will he have a recommendations in advance from the government? He will have his own recommendations. The governor will not be told, I'm giving you the recommendation, please take it as my advice. And then the governor looks at the recommendation, he goes back to the House and says, please consider my recommendation. They're not his recommendation. They're the government's recommendation. It's absurd to say that. It doesn't make any sense. Therefore, the advice of the Council of Ministers will have to be completely kept out of Article 200. So if the governor will look, the government tells the governor, I want you to give assent. The governor, as I said, he will exhaust other two possibilities, withholding or sending it to the president. Sometimes the government also may say, send it to the president in order that we have an expeditious resolution of the question of repugnancy. Maybe rare cases. But the government will never tell the governor, you please don't withhold your assent. And what kind of advice will that be? Therefore, the only advice the government, with a consultation process, is an entirely different footing. When the government has decided to withhold an assent, there will be a consultation process. And that will reach somewhere or the other. Either the bill falls through or something else takes place. Therefore, in order to now put them all in a straitjacket on two what called limiting principles, that the advice is binding on the governor does not have any independent judgment under Article 200. I say it takes the entire life or essence of Article 200. It makes it a lifeless piece of legislation in the Constitution. One more, I may require under 10, 15 minutes after lunch.
No.
Then can I continue for some time?
5 minutes will do.
I've been running at a bullet train speed in order to not take a...
Not at a bullet train. You have been, you have been running at a luxury train speed. Going through the American articles and 5 minutes rukne ke liye bol. I'll just take another 10, 15 minutes for Lordship's break, and Lordship will not mind. I'll try to run through my submissions. We'll go through your submissions.
No, your Lordship will certainly go through my submission. I have no doubt about that. Nobody has a doubt about that.
Continue, yes.
Okay, very well. I was trying to understand for myself if Article 200, a pre-law position, because it becomes a law, it's a bill stage. And 361 talks about powers and functions of the governor and the president. The words use of powers and functions is very important. All powers and functions of the governor and the president are designated by these two important words. See, if there is a function assigned, it has a correlation to the power. So the functional aspect of the governor working in Article 200 also says he has got a power to do certain things. So therefore, we want to bring in to a subject to a judicial scrutiny at a stage prior to it becomes law. What kind of doctrines, principles, tools will the court apply to determine whether it is good or bad, constitutionally compliant, illegal, arbitrary, whimsical? How will you apply what kind of principles at that stage? Therefore, to say that it's subject to justiciability, judicial review, seems to be something which would do complete violence to the scheme of Article 200. If at all we're talking about, well, I give reasons. And what kind of reasons? Adequacy of reasons. Good reasons, bad reasons. So what will the court do at that point of time? Therefore, all that the court will do will become part of the deliberations about the law. At a later point of time, when the law has to be challenged, they will not completely vanish out of deliberation. They'll remain as part of a deliberations about the law. Therefore, to bring in a justiciability, judicial review before the bill becomes a law is to open up, as it's called, a new chapter, opening up a new ascent to jurisprudence in this country. I wish we don't have an ascent jurisprudence at all. We don't need to get into an ascent jurisprudence. And therefore, the dangers which are the cautions which a judicial review that the court must be, I think, will be very careful about is say that we all say that in an administrative law context, we have a right to have reasons. And that reasons must be given all right. Governors will give reasons for withholding assent. But if you're going to put it to a scrutiny at that point of time, I'm wondering how it really work. So that reasons must be given expeditiously is all right, fine, no problem at all. But today we have no reason to say we need to act expeditiously. 99% of the bills are given assent within 1 month. So we are now talking about an imaginary proposition where hypotheticals are being presented to the court.
Already addressed by the learned.
Therefore, I would like to probably, we are now, all this will lead, all this
Put to the data of
all this will lead down to a rabbit hole. You may use that expression. So all that lead to a rabbit hole where to draw the line, where will not draw the line, then it becomes a matter of a future meandering exercise. Therefore, the court will probably say that in dealing with Article 200, it's better left to the wisdom and the working of the governors and the president under Article 200. That's I think probably it should rest at that. I begin with saying pro-Christian, therefore pro-Christian is an important proposition. Don't either shrink it or cut it. And if you're talking rightly about the governor being doing a legislative exercise, he is while giving a withholding an assent or otherwise, the governor must also be a lawyer and a legislator. So if a legislator also understands how a lawyer will work, they're working in the mind of a lawyer. Therefore, it's something akin to a lawmaking process. Let's not lose sight of that. The lawmaking process may have several stages, several dimensions, several domains. Therefore, to say that the lawmaking process happens only in the legislature, the same features do not belong to the governor, does not make it less a lawmaking process. You don't have to compare both in order to say the governor is the lawmaking process. So I'll one final argument in my written submissions, I've dealt with that, on the parents patria argument. Your Lordships kindly just pick up those pages in my supplementary submissions. Page number 890. Page number 908, it is volume V. 1.11.
Para 49.
Paragraph 49.
Yes.
Para 49 on. That's it. I quickly run through some of these paragraphs. All lawmaking processes belong exclusively to the domain of the legislature. Till the law is finally made, it will remain in the domain of the legislature. It's well settled that the court will not issue amendments in many matters related to lawmaking. This position will comprehend all lawmaking, namely enactment of statutes, bylaws, making of rules under Article 309 of the Constitution, regulations, etc. Citizens do not have a fundamental right to ask from the court that a particular law be made or that the law be brought into effect. All rights in relation to any law can be claimed only after the law is made. If citizens cannot seek any judicial remedy during the lawmaking process, certainly no other person, including any government, can assert such a right in regard to the lawmaking process or the contents of the law. The engagement of the governor in dealing with the bill presented to her as already stated above is a part of a lawmaking process. The entirety of Article 200 contemplates such a lawmaking process. Between the stages of the introduction of the bill in the House and the culmination of the bill becoming a law, there cannot be any room for a judicial remedial process. No lines of demarcation can be drawn between different classes of legislative action. No citizen will have a right to approach the court to allege that a law will frame the legislature without any delay, or that it will so frame in a particular fashion. If that is so, there's hardly any room for a scope for the state to step in and articulate any cause of action perpetually on behalf of the residents of the state. We have three judgments where your Lordships have said, I'm skipping A.K. Roy and Zaki, etc. But kindly turn to paragraph 55. In Supreme Court Employees Welfare Association, this court was dealing with writ petitions filed by the employees of the Supreme Court praying for pay hike. The court was noting in paragraph so-and-so that the Chief Justice of India, by virtue of the constitutional grant, exercise legislative power when he makes rules under Article 146(2), held that the power of the President and the proviso to Clause 2 of Article 146 to approve or disapprove the rules made by the Chief Justice is legislative in character, and no mandamus was consequently issued in that regard. The President's approval to the rules made by the Chief Justice of the Supreme Court under Article 146(2) as a step towards completion of the rulemaking process and the assent of the Governor towards completion of the lawmaking legislative assembly are clear parallels. Now, the much emphasis has been laid on the Charan Law also would argue that the state may act on behalf of the citizens in its capacity and role as parens patria. However, this selective reliance on the judgment has led to a misplaced and misconstrued understanding of the concept of parens patria. The Honorable Court, while dealing with the concept, ultimately noted that if the act in question, which is enacted in recognition of the sovereign to act as parens patria, in a special situation where the citizens had been victims of a wrong, which at their own level and reach could not have been redressed. The court also importantly cautioned that conferment of power and the manner of its exercise are two different matters. Then again in Aruna Shanbag, I read two paragraphs, paragraph 58, it's para 126 and 130. The doctrine of parens patria had originated in so-and-so. It implied that the king is the father country and the obligation so-and-so. Next slide. The idea behind parens patria is that if a citizen is in need of someone who can act as a parent, who can make decisions and take some other action, sometimes the state is best qualified to take on this role. In our opinion, in the case of an incompetent person who is unable to take a decision whether to withdraw life support or not, if the court alone of the parens patria which ultimately must take the decision, though no doubt the views of the near relatives, next friend, and doctors must be given due aid. This doctrine has been invoked the Honorable Court on behalf of the state and behalf of the court as a state in so-and-so in N.M. Thomas, time and again in cases where the court has found a petitioner to be incapacitated to take decisions on behalf of himself. Some of the examples where the parens patria has been considered by the court are listed as under. I skip all those instances. Now, therefore, kindly now come to page 915, paragraph 61 to 63, para 60. It's worth noting that the parens patria doctrine is an enabling proposition, and within the four corners of the need of protecting legitimate and cognizable interests of citizens, where there is no cognizable right or interest, such as in the instant case, during the lawmaking process, there is no room for the parens patria doctrine. The doctrine of parens patria is a source for the state to litigate on behalf of citizens who cannot help themselves has been well documented. However, this power is not absolute and has its own limitation. It is submitted this power cannot be misused by the state or the federal unit of the large nation state to agitate a cause against the central or federal government. It was stated that while any set of people may be citizens of a state, they are also citizens of the nation. And the remedy lies not in a state agitating their cause against the center, but rather in ensuring that the state policies are duly implemented. The invocation of the parens patria doctrine in various jurisdictions shows that the efficacy and the relevance of the doctrine lies in those circumstances where, as is stated below, that a class of persons who have legally recognizable rights, claims, or interests are not in a position to access justice or need not be burdened with the task of accessing justice. That's the limitation in parens patria doctrine. Not that you have a freewheeling right to say, I am litigating on behalf of the citizen. So, paragraph 64, finally, that's why the state of the parens patria is duty bound to provide assistance to all its citizens, and especially to those who may not be able to protect themselves on their own. The state cannot and ought not to resort to risk jurisdiction to seek mandatory writs against the central government, which also acts as a parens patria to the citizens. The parens patria doctrine is thus alien to the field of lawmaking as understood above.
It is already covered by the learned solicitor.
Yeah. Well,
Hope argument with regarding the governors misusing the
I
power.
just come back to only one small final comment on it. Since we have been talking a lot of hypotheticals, right? I'm not saying the court will act on my statement of the data or their statement on it. I'm not talking about that. Since we're talking about hypothetical being present, the reason for the court to necessarily read Article 200 in a particular way. You lots have seen.
The reason for the court to read is because of the
No, you
presidential
lots have
reference.
seen in the, kindly turn to page 920 for a minute. There are two.
We are not going to go into that.
No, I'm not asking.
That we have already told the
I
learned.
am not asking lordships to have any comment on the data and use it for the, as a basis for the answering the reference. I only want to draw attention to this fact that, can you turn to only two facts in Appendix A and Appendix B? Why I am talking about it, this is a useful data to find out whether my interpretation or anybody's interpretation of reading Article 200, I don't want both extremes to be looked into. I'm not saying 95% is then therefore condone this, or saying 0.8 is insignificant, therefore don't look. I'm not saying that. But it's an important pointer for the court. It's a very important pointer for the court to understand whether the extent to which a court will go in reading.
This is already placed on record by the learned solicitor also.
You know, okay, just look at this.
It's already placed on record by the learned solicitor.
One way of looking at it. That's all. What I'm saying is, on page 920.
Beyond the reference. If the president has put data, we would have answered it.
Well, it's okay.
Fair.
All of us. I'm not saying you. I'm not saying what you said. I'm saying something else.
No, I know what you're saying.
I'm not saying.
Anyway, thank you, Mr. Adoni. Thank you.
Just make a note of that.
May I take Malas 90 seconds if your logic permits me? I'm not going to argue. I'm not arguing, Malas. I just want to point out. I'm not arguing. One second. I'm not arguing. I just want to point out that this thing that my learned friend is. Yeah, he's pointed out this withholding assent. That declaration applies also to granting assent for sending it to the president. I'm not arguing. I'm just pointing this at. See, for God's sake, don't think I'm arguing the matter, mother. The other
200 says.
my learned friend. All right, I will not say anything, mother. It's very unfair, mother.
I didn't want to say anything about this because your lordship will not go into the data. It's what Mr. Solicitor only pointed out how in a given case.
My intervening application
One case the governor withholds. I am entitled to come to court and say, how is he withheld?
Lord, yesterday I mentioned.
Forget about the data.
So it has been a very enlightening debate. Thank you very much to all of you.
Yesterday, my lord, I mentioned my intervening application may be allowed, my lord.